Hello and welcome back to another lazy lesson. Today we shall be discussing about the Law Commission of India, its historical background, its functions, key roles and key recommendations of various law commissions. We have taken up this topic because the Union Cabinet recently gave its approval to constitute the 22nd Law Commission. So the Law Ministry will now notify the new panel which will have a 3-year term. So first of all, what is the Law Commission? Is it a constitutional body? Is it a statutory body? What kind of body is it? Well, please note here that it is neither a constitutional body nor a statutory body. It is just simply an executive body established by an order of the Government of India. And this executive body will have a fixed tenure of 3 years. So what is the historical background of the Law Commission? See, it basically has pre-independence origin, but after independence, the first independent law commission was constituted in the year 1955. And since 1955, we have had 21 independent law commissions which have made various recommendations towards the progressive development of India and codification of various laws in India. Let us now briefly understand the pre-independence origin of this law commission. So before independence, the first law commission was established in 1834 as per the provisions of the Charter Act of 1833. And Lord Macaulay headed this commission, and its key recommendation included the codification of the Indian Penal Code and the Criminal Procedure Code. And thereafter, 3 more law commissions were constituted in the year 1853, 1861 and 1879, and their main accomplishments include the codification of Indian Code of Civil Procedure, the Indian Contract Act, the Indian Evidence Act, the Transfer of Property Act, etc. Next, we'll have a look at the composition of Law Commission. Who are the members of the Law Commission? See, the commission mainly consists of legal experts. It has a full-time chairperson and 4 full-time members. And amongst these is included a member secretary. Besides, law and legislative secretaries in the law ministry will be the ex officio members of the commission. And the commission shall also have 5 part-time members and not more than 5. So who can be a chairperson of this commission? See, as per the convention, a retired Supreme Court judge or former Chief Justice of a High Court can head the commission. Like I mentioned earlier, so far 21 law commissions have been constituted, and the last one was constituted under the chairmanship of Justice B.S. Chauhan. And the key issues on which this commission submitted its reports include simultaneous elections to the Lok Sabha and assemblies and uniform civil code. In the present scenario, both of these issues are being hotly debated in India. Various judicial experts and politicians, including the President of India and the Prime Minister, mentioning about simultaneous elections. And in the light of the Supreme Court's verdict in Triple Talaq case, the need for a uniform civil code has been felt. But time and again, the challenges in having a uniform civil code have been highlighted in India. So the next question we have is, why do we need a law commission? What are its key functions? See, the law commission here, on a reference made to it by the central government or suo motu, undertakes research in law and review of existing laws in India for making reforms therein and enacting new legislations. Besides, it also undertakes studies and research for bringing reforms in the justice delivery systems for eliminations of delay in procedures, speedy disposal of cases, reduction in the cost of litigation. And other key functions include review or repeal of obsolete laws, suggest enactment of new legislation as may be necessary to implement the directive principles of state policy and to attain the objectives set out in the preamble of the Constitution. Likewise, it will take all such measures as may be necessary to harness law and the legal process in the service of the poor. But before finalizing its recommendations, the Commission will consult the nodal ministry or departments and such other stakeholders as the Commission may deem necessary for the purpose. Now, why the need for having a law commission was felt? See, before independence, there were no uniform laws across the country. So the British felt that it was necessary to have a codified common law to administer the whole of country. So they constituted various law commissions before independence. But post-independence, the constitution stipulated the continuation of pre-constitution laws under Article 372 until they were amended or repealed. This meant that to administer the independent India, we had to follow the laws which were present prior to independence, that is constituted or made by the British. But various experts opposed this move because they said that British had made laws according to their needs and wants. they had the intention of looting India or exploiting India economically. So those laws were not relevant for the independent India. And hence, both inside and outside the parliament, there was a demand for establishing a central law commission to recommend revision and updation of the inherited laws to serve the changing needs of the country. And hence, the government of India established the first law commission of independent India in 1955 with the then Attorney General M.C. Setalwad as its chairman. So here is a quick look at the various reports submitted by various law commissions so far. If you observe closely, you will see that the reports are based on various hotly debated topics at current times. These include hate speech, criminal law amendment bill, that is provisions dealing with food adulteration, the protection of children, inter-country removal and retention bill, amendments to criminal procedure, compulsory registration of marriages, human DNA profiling, assessment of statutory framework of tribunals in India, implementation of United Nations Convention Against Torture, review of Contempt of Courts Act 1971, legal framework on gambling and sports betting including cricket in India, and BCCI versus Right to Information Act of 2005 and other such issues. See, now the Law Commission here is not a sacrosanct body. It too has some issues or concerns which need to be addressed. So before recommending some reforms, let us understand the issues or concerns being faced in the Law Commission. See, firstly, unlike its sister organizations, that is the National Commission for SC, ST or OBC, the Law Commission has no fixed composition, no defined eligibility criteria or no set of functions. Everything here rests on the will of the government, and the terms of reference are specified afresh each time it is reconstituted. So now, if the commission has to work without regard for extra legal and political considerations, it must have a governing statute defining its powers and responsibilities and limitations more importantly.